Did your mother's cousin's aunt leave you an inheritance? Hi, I'm Darren Findling of the Probate Pro, and we're going to cover Michigan's intestate laws. These are the laws that relate to who is identified as an heir when somebody dies without a will. An heir meaning the right to inherit those assets that the person that died left behind. Let's cover this by examining a family tree. We're all familiar with these family trees. We've probably created one for our own families. Let's explore when and how Michigan's intestate law applies to your particular circumstance or to a fictitious family tree. So the first thing we want to know is, did the person have a will or no will? The word testate means with a will, and the word intestate means without a will. So the first thing we examine is, did a will exist, or did the person die with no existing testamentary document or testamentary device that would be admitted to probate and used for the distribution? Of course, if a will is admitted to probate court, it trumps all of the laws relating to intestacy, meaning whatever is existing within that will, the directions for the gifts within the will determine how the assets are distributed. And then, of course, conversely, without a will, it goes by Michigan statutes to determine who has the right to inherit what. So the person in this particular box is what we call the decedent, the person that died, the subject of the family tree. We like to always start with that person because as we describe relationships, rather than describing the relationship to the person who's reporting the information to us, we want to describe it from the vantage point of the decedent. So, was there a surviving spouse? Pretty straightforward question. When somebody is a surviving spouse, Michigan has a very specific statute that identifies when somebody is not a surviving spouse. It's very limited. There are some desertion laws relating to it, but a person that is married and may be beginning a divorce proceeding is still a surviving spouse. There are times that your surviving spouse status can be lost, as I mentioned, desertion or bigamy or some other technical reasons, or in the event of what we call the slayer statute, when somebody murders the other person, you can lose your rights to inherit. But generally speaking, we want to identify if there's a surviving spouse, because the surviving spouse is really key to the laws of intestacy. From there, we want to know, are there issue of the decedent? And the word issue is kind of a fancy word for simply saying, are there children? Are there children who the decedent was survived by? Now, when we ask this question, we don't say, are there children of the decedent? Because oftentimes people will only answer to those children who are then alive. So we frame the question this way. We say, did the decedent have any children during their lifetime? And we want to represent those children here on the bottom of the family tree, and we list them all. In this particular case, I think I've got about 7 boxes, but of course there are families that are much larger and some that are much smaller. Any child of a decedent who predeceased, that means died before the decedent, we still would reference there. But we want to then dig deeper and explore if the predeceased child had a child of their own, which would be a grandchild of the decedent, and so on and so forth as we go lineally down from the decedent. Any decedent that had a child that died after the decedent by at least 120 hours, we also want to reference there because they're still entitled to inherit. So when there's a surviving spouse and children, the conversation ends there. We don't have to worry about siblings and cousins and uncles and aunts. Surviving spouse and children would inherit, and that would be the end of it. If there's a surviving spouse and no children and no parents, the surviving spouse takes all and it ends there. But what happens if, as we described here, there are just grandchildren and no children? Well, then yes, the grandchildren would take. But there are situations where there's a surviving spouse and the surviving spouse I skipped one frame here, but if the surviving spouse had no children but has parent or parents alive, those would be the heirs of the decedent. And then if there is a surviving spouse, no surviving spouse, no children, grandchildren, no parents, grandparents, but there are siblings, then the siblings take. So Michigan has this defined statute called the intestate statute that we really study carefully because, of course, family trees can be quite complicated. There are situations where there are half siblings or step siblings. There are cousins. There are really complicated family trees when somebody has died many years later and we are dealing with many post-deceased children or nephews and nieces and so on. To really understand and explore the family tree of your particular circumstance, call us. We're happy to discuss it and go over the family tree to identify who the intestate heirs are of the estate. At the Probate Pro, we're passionate about probate-related issues. If you have questions about who a probate heir is, or any question about a probate issue, call us at 833-PROBATE or visit us at theprobatepro.com.